A hush falls on the crowd, so I guess we'll get started, even though some people still in line. My name is Chris Green. I'm the Executive Director of the Animal Law and Policy Program here at the Law School. I'd like to start by thanking the HLS SALDEF, the Student Animal Legal Defense Fund, for organizing this. And thanks to Nathan Herschler for taking the time to join us. Last month, I went to Johannesburg to take part in the CITES, the Convention on International Trade in Endangered Species. They have a convention of the parties that's held every 3 years. This was the 17th one of those. And so I went down as an observer on behalf of the program, and it was pretty eye-opening. Seeing the sort of international diplomacy dance firsthand that's so super dry and genteel on the surface and just millimeters below is just an absolute bloodbath of horrors of backstabbing. I don't know if this is in your presentation, but
that's a good one.
One of the most absurd things I encountered, there's just so much distrust among a lot of the parties. And so in this big convention center, the Wi-Fi kept going down because it was getting overloaded for too many people. And there literally were some of the smaller delegations that were circulating a rumor that China had actually brought their own hackers with them to take the system down to prevent any progress on some of these issues. I mean, that was for real. The idea was to talk about this, but Nathan was there, and as you'll hear in a minute, he led the delegation for the International Fund for Animal Welfare, which has their international headquarters right down south of us on the Cape. So I thought he would be able to speak a lot more cogently to this, so we brought him in. Nathan is the director of global program operations for IFAW, and he's responsible for program and operational management across IFAW's 14 offices across the world, and 6 programs worldwide. He leads IFAW's program planning, monitoring, and evaluation function, program and country office budgeting and financial management, and is responsible for aligning operations to business and program strategies. Nathan has expertise in strategic program and business planning, international environmental law, facilitation, and change management. And prior to his work in this role, Nathan led IFAW's involvement in US-based litigation and domestic and international policy initiative for the protection of wildlife. And most relevant to today's lecture, as I mentioned, Nathan led IFAW's Committee 2 engagement at CITES COP 17 in Johannesburg last month. So without further ado, I'll turn it over to Nathan, and he can let you know what really happened. Thanks.
Thanks so much. Wow, that's loud. And there's a lot of you. Thanks so much for coming, and thank you for hosting me. It's really, really great to be here on Election Day. This is going to freak me out. Do it a little lower. I'm really happy to be here and talk about my experience at the CITES COP, and I was asked actually to give a little bit of context about CITES and international law and what the formation of that was as well. So I'm going to start off with a couple minutes of that, and then get into just a really quick survey of what happened at the CITES conference. As Chris said, a lot of things that happen just under the top layer, and it is. Has anybody here been to an international conference before? UNFCCC? Yeah. Okay. Great. Which one was it? Yeah. So as any of you who've been to one of these things can attest to, they feel big and bureaucratic and administrative, and everybody's being very formal and cordial. And as Chris noted, things are going on just below this veneer of appropriateness that are really interesting. Whether they be allegations of corruption, people yelling at poor observers who accidentally cross an invisible barrier between the parties and the observer area, media inappropriately taking pictures of people's screens and posting it online. So all these things do end up happening and causing little minor issues during the conference. I'm not really going to talk about those today. If anybody wants to talk about the drama of CITES, I'm happy to after this or during the question and answer period. Anyway, thank you all for being here, and thanks to Grasshopper for the food. It's yummy. All right, does this work? It does. That's great. So quickly, just presentation objectives. So I'm going to quickly, as I said, go over what CITES is all about from its purpose and then how it's implemented. And then I'm just going to quickly run through all the successes and some of the sort of pseudo-successes and losses that we experienced at this COP. And I will pause after those two presentation issues and give you guys an opportunity to ask any questions that you have, either about CITES itself, about the process, or about the experience, or about the actual animal issues we were dealing with. All right. So first, what's CITES all about? CITES comes back to Article 31, and I don't have this memorized, so I'm going to look down. Article 31 of the Vienna Convention of the Law of Treaties states that a treaty needs to be interpreted in good faith and in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and its purpose. And so CITES gets a lot of press, I think, because there's actually two interpretations of the purpose of CITES. There's a lot of parties, particularly in the developing world, and a lot of NGOs that focus on sustainable use of wildlife, and even the Secretariat itself, who argue that the CITES treaty is actually primarily oriented as a trade facilitation treaty, one that's aimed at promoting the legal and sustainable trade in wildlife. There's other parties, other developing world parties, a lot of the developed world, various Secretariat representatives, including John Scanlon, who's the chair of the Secretariat at the moment, have all indicated that CITES needs to be implemented in a way that strictly manages and polices the international trade in wildlife to ensure that overexploitation of wildlife actually just doesn't occur. So I'll tell you really quickly why I think our interpretation, the animal welfare and conservation-oriented perspective, is the correct one. And I'm happy to discuss this in any further detail again during the question and answer period. But so when you look at international law, the first place to start looking is at the preamble when you're looking to the purpose of it. And the first paragraph of the CITES preamble, and the preamble in general is just a pretty short one. So if any of you guys have your computers pulled up, there's 4 paragraphs. And so you can read through this yourselves and get your own interpretation of whether it's a trade-oriented or a conservation-oriented treaty. From our perspective, it's a pretty conservation-oriented treaty. The first paragraph recognizes that wildlife must be protected because they're an irreplaceable part of the natural systems of the earth. The third paragraph casts people and states in the role of protectors of wildlife. And the fourth paragraph focuses on the international responsibilities shared by states, stating that cooperation is essential for the protection of certain species against overexploitation through international trade. So from our perspective, those 3 key pieces of the preamble are really key in interpreting what the purpose, then, of the CITES Convention is. So CITES has a long history. This is the sort of second way that we would want to interpret the purpose of CITES itself, and that's through sort of its legislative history. In 1961, the IUCN, which is the World Conservation Union, if any of you guys have heard of that, it's been around for a long, long time, but they called for an international convention in 1961 to regulate the illicit wildlife trade, especially those of endangered species. They subsequently circulated a number of drafts, and over the next 10 years or so, they actually did a fair amount of lobbying in the international community to try to get something moved forward. Then in 1972, the Stockholm Conference renewed the call for an environmental treaty associated with wildlife trade in endangered species. And then finally in 1973, the US actually convened the Washington Conference, where the text of the CITES Convention was actually finalized and then put into force. So throughout those decade-long negotiations, and I don't have any quotes from the people who were negotiating at the time, it was before my time, but they never deviated from the purpose, which was actually the Convention's basic premise, which is species protection. So that's just a really brief background then into what the sort of history and purpose of CITES is in the context of international law. All right, so very quickly, how does it get implemented? This is the sort of the practical how-to component. So we have Appendix 1. So Appendix 1 is roughly equivalent with the US Endangered Species Act. In fact, the U.S. Endangered Species Act implements the CITES Convention. And so you'll see a little bit of parallel language if you do a comparison between the treaty language and the ESA itself. So Appendix 1 is a list of species that are threatened with extinction, which are or may be affected by trade, and that's a really broad definition. It means that the species who are endangered that are on Appendix 1, it doesn't have to be the primary reason that they're endangered is that they're in commercial trade. It just has to be that they're affected. Their conservation status is affected by international trade in those products. Or that they may be, if we have a deficiency in information, and that does happen every once in a while. So Appendix 2, in contrast, is species that may become threatened with extinction unless the trade is strictly regulated to avoid use incompatible with their survival. It also includes look-alike species, and so and I don't talk about this later in the presentation. But one of the issues that was actually on the agenda for this CITES COP in Committee 2 was whether CITES has the authority to regulate mammoth trade. Mammoth obviously being an extinct species, but with mammoth ivory being something that looks a lot like elephant ivory or even rhino horn in certain substances, and so that one ended up being a case where there were two perspectives on it. A number of parties were arguing that the CITES treaty does not regulate extinct species at all, and so that it was not regulatable under CITES. A number of other organizations were saying it falls under the classic look-alike provisions of the CITES Convention, whether or not the species at issue was extinct or not. And then there's an Appendix 3, and nobody deals much with Appendix 3 from a practical perspective, although it does have a substantial list of species that are on various Appendix 3 lists. And Appendix 3 listings are unilateral listings by any party. And so if you're a country who cares about an issue related to some species that you have, you can just unilaterally say that we want this species up on Appendix 3. It means that country then is responsible for issuing export permits, but there's no non-detriment finding required. And I'll talk about non-detriment findings in a minute. That's sort of the meat of what the permitting process of CITES looks like. Okay, so then we have the CITES permit regime. And so why do Appendix 1 and Appendix 2 and Appendix 3 listings matter? It's because they actually have certain requirements associated with each of them. For both Appendix 1 and Appendix 2 species, CITES requires that the state of issue, the country where the wildlife specimen is actually coming from, actually issue a permit saying that the commercial trade in this product will not be detrimental to the survival of the species. The permits that are issued as a result of this process are called NDFs in common parlance, and it requires a scientific assessment by those countries to make this determination. There's been some debate in the past about whether the non-detriment findings may also require economic assessments or assessments of demand in some of the countries where the products are likely to go to, but the sort of standard is that it's really about the conservation status of that species on the ground and whether the commercial trade is likely to affect that species. For Appendix 1 listed species, beyond the export country actually being required to issue a non-detriment finding, the country of import also has to issue a non-detriment finding. The non-detriment finding from the country of issue is sort of a check then on the authority of the scientific management authority of the state of export. And a lot of the times what you'll see, especially from some of the countries who are more sustainable use oriented, is that they're going to be far more willing to issue NDF findings about the trade in their species from their places. And so Namibia is a very good example of this. And then you'll get countries of receipt, so the importing countries, like the United States, who will actually have a separate assessment that comes to a contradictory finding. And so you may have valid export permits and a decision by an importing country's management authority that they won't accept the permit and not issue a non-detriment finding. The country of import also has to be satisfied that the trade is not for primarily commercial purposes, and so CITES has a number of allowable, permissible trade provisions for things like trophy hunting, which they deem non-commercial trade. That's true for trade for education purposes as well. And so live animal trade is non-commercial under CITES as long as it's for education or scientific purposes. So that's something else that's regulated under CITES, but it's not considered commercial trade and has a different permitting structure associated with it. So that's just the sort of top-level how-to then of how CITES works. And again, I can get into a little bit more detail if anybody has questions during the question-and-answer period. But I wanted to make sure that we had enough time to actually get to the recap of CITES COP17, which is where you're going to get all of my pretty pictures of animals. So how does this CITES compare with some of the others? This is one of the questions we've been getting a lot of recently. So in the words of Secretary John Scanlon, he described this COP as a game changer. And he says that it's going to be remembered as a point in history when the tide turned in favor of ensuring the survival of our most vulnerable wildlife. We've had a lot of lack of success at CITES in the last 8 years or so. We've had a number of big species proposals that were up that just didn't go anywhere. Things like polar bears, which also didn't go anywhere at this COP. It wasn't even proposed. Were big losses for the conservation community. And the sustainable use crowd was really excited about what had happened in the last few COPs. In this COP, we sort of saw a reverse of fortune. And it may be partially because the COP was hosted in South Africa. I think the rhino and elephant poaching crisis being so in the news right now has probably had a substantial part in this sort of shift in perspective. And I think there was a longer lead-up time in the press as a result of both parties and country positions being considered press-worthy, especially in the European Union. And I'll talk about that in a few minutes as it relates to elephants. But I think there was a lot of pressure to reorient a lot of the parties' positions on conservation issues during this COP. 62 species proposals were submitted prior to the COP. So all the species proposals go to Committee 1 of the CITES COP. And those are about either bringing things onto one of those appendices for the first time, or removing them, or transferring them between any of the 3 appendices of the CITES. There were 16 mammal proposals, 4 for birds, 14 for reptiles, 5 for amphibians, 6 for fish, 1 for Nautilus. I didn't know what a Nautilus was before this COP. 1 for snail, and 13 for plants. There were also another 85 proposals that were submitted or so, and that doesn't include the sub-proposals in Committee 2. So Committee 2 was really, really stacked during these 2 weeks with a lot of stuff, and the decision for what goes into Committee 2 versus Committee 1 is a little bit hazy, a little fuzzy, but for the most part, the Committee 1 issues are all the species uplistings and downlistings, and then all the sort of more technical, legal, and procedural issues are in Committee 2. Okay. Of the 62 proposals submitted, 6 were withdrawn. 14 submitted involved a proposal for lesser protections. 42 submitted were for greater protections. 10 of those 14 looking for lesser protections succeeded, and 4 failed. That's not necessarily a bad thing. Sometimes that means that the conservation status of those species has changed. 41 of the 42 proposals looking for greater protection succeeded to some degree. So from a policy perspective, that's a pretty substantial success rate. From a conservation perspective, it sort of points to the fact that there's a real big problem happening right now. So whether or not it was one of the worst or the best COPs is a little bit depending on your perspective. And as I was saying before, we're a little bit tainted by the fact that the last couple COPs were really bad for the conservation community, and so for this one, we actually sort of had a sustained feeling of really positive results from a lot of the proposals in both Committee 1 and Committee 2. And just procedurally speaking, I'm going to talk a little bit about what the vote counts were, or refer to a couple of the vote counts for some of these species issues. For substantive changes at CITES, it requires a 2/3 majority to make changes. For non-substantive issues, for some of those Committee 2 issues that don't address, that don't reflect in a change in the CITES Convention itself, it only requires a simple majority. But for the most part, the things that I'm going to be referring to in here actually would have required a 2/3 majority to pass. Okay, so winners and losers. Pangolins, this is a pangolin, if any of you guys haven't seen a pangolin. And about a year ago, probably none of you would have seen a pangolin, but they've really exploded onto the news the last year or so. And they were big winners at CITES. There were 4 proposals. They covered 4 Asian and 4 African pangolin species. They were championed by 18 of the range countries in the United States. Prior to the COP, all 8 species were on Appendix II with 0 quotas for the 4, and there were 0 quotas for the 4 Asian species. There were no quotas for the African species of pangolins. So pangolins are actually currently the most traded species in the world. There's over 1 million of them thought to have been illegally poached and trafficked in the last decade. I want to focus on this one just a little bit in more detail because IFAW actually had a relatively substantial role, and the nonprofits in general actually had a pretty substantial role in this. IFAW working with the US and Vietnamese governments, HSI, NRDC, HSI is Humane Society's international wing, Freeland, which is an organization based in Thailand that does similar work, had all convened a meeting in 2015, right before the Standing Committee, and really brought attention to this issue to the point where almost all of the range countries were supportive of uplisting proposals at that time. That allowed the parties themselves and a lot of these nonprofits to spend those intervening years between the last Standing Committee, and those are the intersessional between the COPs meetings that they have, the Standing Committee and the COP itself, lobbying a lot of the countries around the world. So as a result of that policy work that was done well before this current COP, 3 of the 4 proposals actually just passed by consensus. There was no debate associated with them whatsoever. There was only 1 species, the Sunda Chinese pangolins, that were challenged for a vote by Indonesia. The vote total for that one was 114 parties voted in favor. There were 5 abstentions. They probably just weren't in the room. And then there was just 1 against, 1 opposition, which was Indonesia itself. so for this, I mean, these guys just had a wave of victory in this one. Again, it's a result of a tragic situation on the ground for the pangolins. And if you guys want to learn more about pangolins and sort of what they're going through right now, I really urge you to do so. There's some really great organizations that are trying to fix some of these challenges. Historically speaking, pangolins haven't been able to be rescued and rehabilitated after they've been seized from illegal wildlife trafficking. They don't live that long if they've been in wildlife trade, but there have been some really substantial advancements in this. So there's some good work to do still on pangolins. Okay. This is the Barbary macaque. And they were also big winners at the COP. So the Barbary macaque is native to Algeria, Morocco, and the UK on Gibraltar. There's only between 6,500 and 9,100 of them left in the world. The proposal was offered jointly by the EU and Morocco to transfer the species from Appendix II to Appendix I. And again, its biggest threat is habitat loss, you can sort of imagine, as a result of lack of the forests in North Africa. But it's also pretty substantially affected, in this case, by commercial pet trade between from Morocco and especially into Spain and southern France, where North African communities are relocating into Europe. And so we have documented international pet trade with over 200 being taken from the wild annually, and we suspect that that number is actually relatively low. Even with only 200 a year out of a population total of 9,500, you're asking for trouble. So these guys were afforded some nice new protections. The next one was, this is the African gray parrot. We expected this to be one of the biggest fights at the COP itself. The proposal was from 7 range countries and then also the EU and USA, and it was again for a transfer from Appendix II to Appendix I. And they were also winners, thank goodness. The DRC was where most of the trade is actually coming from. They plan to object. And this one actually came to a secret ballot. And so at CITES, this almost always backfires on the countries who ask for a secret ballot. So procedurally speaking, any country can ask for a secret ballot. They have to have 10 other countries support them. And if you get those 11 parties who support your proposal to have a secret ballot, it goes to secret ballot, and you'll just have vote totals that show up. They hide all the screens, and nobody can see what the votes are. It actually was really confusing in committee too, because they were using new technology for the first time, and people were trying to multi-vote because they couldn't see that they had actually voted or what they had voted on. And so they had to do three different votes before they got it right on some of the committee 2 issues when it came to secret ballots. But for these guys, they passed with 95 in favor, 35 against, and 5 abstentions. I think 5 parties just didn't show up because we had a lot of 5 abstentions. This is a big win for them. Again, another species that's traded really, really heavily from the wild. It's much easier to capture wild African greys than to breed them, although there is a substantial breeding population, which makes it really easy to bring in some of the poached wild birds into the legal commercial trade. All right. We also have a lot of marine species. So this is actually one of the bright spots from the previous COPs. We had some good successes on white tips and hammerheads and porbeagle sharks at the last COP, and as well as some manta ray species. The winning streak for these guys continued at this COP. Silky sharks, thresher sharks, and devil rays were all placed on Appendix II for the first time. Again, I feel bad stating winners on all of these because it means, again, that overfishing is really contributing to a pretty substantial problem for these species. Sharks almost all over the world are suffering as a result of bycatch, if not being specifically targeted by commercial fisheries. This here is the Nautilus. And if you were wondering what a Nautilus looks like, as I was, this is what they look like. It sort of looks like a shellfish with terrifying tentacles coming out of the side of it. Luckily, it's quite small. So it received protection for the first time on Appendix II. It was introduced by Fiji, Palau, and the United States. The United States, as you can tell, is very progressive when it comes to these things. They're a co-sponsor on almost all of these proposals that were substantial winners. The creature is found in Indo-Pacific waters with a limited distribution, so it's not found in open waters or in water below 800 meters. The worldwide market for Nautilus products is it takes about 900,000 animals a year, and it's mostly used for souvenirs or jewelry and such. And these guys were winners also, so that's great. And then we had a bunch of plants. That's not something that we worked on as the International Fund for Animal Welfare. But again, they were winners. Rosewoods, encephalitis, which I thought sounded a bit like a communicable disease, but is apparently a really pretty fern. All were winners at this COP. And they were mostly passed by consensus, which was really interesting. So CITES has both an animals and a plants committee. IFAW obviously doesn't really participate heavily in the plants committee, but they've done some really amazing stuff. And this is a place where actually the commercial industries have actually, I think, cooperated pretty effectively on some of the conservation issues. We were sitting next to the International Fragrance Association by virtue of our organization starting with international, and F as the second word. And they seemed very, other than they're still pro-utilization, but they certainly are interested in making sure that the trade is sustainable for some of these plant products, which is good. So rhinos, I mentioned a little bit already. We again expected this to be one of the most public fights at CITES, especially because South Africa was the host country of this COP, and they have a relatively robust population of rhinos that are, and I don't know how familiar you guys are with the sort of management structure of South Africa, but most of their wildlife are kept in private reserves where commercial trophy hunting is permitted, including for rhino. So we expected a little bit of a fight as it related to trade in wildlife horn, in rhino horn. And we suspected that South Africa was going to ask for an opening of trade in rhino horn by amending what we have now, which is an Appendix II with an annotation to permit trade in rhino horn from captive species, captive populations. South Africa didn't end up doing that, maybe because it was going to be such a big publicity issue and it was likely to fail. Swaziland, which is that little tiny kingdom within South Africa, did end up proposing it. It also went to secret ballot, and again, another case of secret ballots backfiring on the parties. 26 parties supported, 100 were against the removal of the annotation to allow for trade. So that's a status quo situation. Rhino horn is still not permitted. Peregrine falcon. There was a proposal by Canada to transfer this from Appendix I to Appendix II. That was based on the biological status that they had undertaken in Canada. This species is really highly valued for trade, particularly between Africa and the Middle East. In the Middle East, we have a really substantial falconry practice. And IFAW has an office in the Middle East, and so we worked really hard on this issue as well. The proposal was to loosen protections and allow for monitored trade, and we worked really closely with a lot of the countries in the Middle East, as well as those in Africa and the African Elephant Coalition countries, to fight to maintain the status quo on this one. And again, it was rejected with 52 in favor, 57 against, and 12 abstentions. And again, this one was much closer, and I think probably closer because of Canada's perception that species-wide, the population is actually doing better recently. But because commercial trade is such a substantial issue, and we didn't want to see it better, the parties did decide that they wanted to maintain the status quo, and as listed on Appendix I. Okay. And then there's always drama related to elephants at the CITES COP, literally always. Every COP since 2004 has dealt with the elephant issue. There were 3 listing proposals, and there were also 3 proposals in Committee 2 associated with those 3 listing proposals on elephants. So the listing proposals, there was one from Namibia to lift its annotation, and I can give you guys a little bit more detail after the fact on what this annotation was all about. But basically, that would have allowed them to resume normal Appendix II trade of the animals coming from that country. There was another one from Namibia and Zimbabwe looking to remove Zimbabwe from a similar annotation. So both of those were defeated again in secret ballots. There was again only about 20 parties that supported the removal of the annotation language. There was also a proposal from 13 of the range states in Africa, and this is that African Elephant Coalition. This is headlined by Kenya as sort of a leader, but involves most of the East African countries. That was to transfer all elephant populations from Appendix II to Appendix I. That proposal also failed in secret ballot, although it was much closer, and we weren't expecting this. Kenya's proposed this every COP for the last 4 COPs, and it's lost every time. And this time, for the first time, we had 62 parties in favor, 71 against, and 12 abstaining. It was actually the European Union with their 29 votes, and they sort of vote together on this. 29? Yeah, 29 votes. And the United States. who sort of swung this one in favor of lesser protections. And the European Union took a huge amount of heat for making their position on this issue public before the COP. They, in the media, and WWF also. So both the European Union and WWF were saying that an uplisting for some certain elephant populations just did not meet the biological criteria for uplisting. That may be true. It may not be. Our organization's perspective is that an uplisting would be a good thing for elephants, given the crisis at the moment. But the EU did go through, despite the fact that they were just getting hammered for the month or two before the CITES COP about their positioning on this one, to vote against, and the US joined them, and it was based on that biological assessment that both of those, the European Union and the US had done. Interestingly, during the COP itself, there was some indications beforehand that Botswana, which is usually one of the Southern Africa pro-use countries, are referred to as SADC countries, and those countries almost always vote as a bloc. And for the first time during this COP, Botswana actually indicated that they would have considered uplisting their population to Appendix I, which is really actually a substantial political victory, even though it didn't actually happen in the voting. So we're expecting some good progress on elephants in the next time. And I'll go really quickly through these last ones because I know we're almost out of time. A couple losers here. Reptiles and amphibians received new or greater protections to some extent, but there were also a number of crocodiles species. The Morlitz crocodile in Mexico and the saltwater crocodiles in Malaysia had their existing protections weakened. And then for lions, there were 9 countries who had proposed a transfer of African lions from Appendix II to Appendix I. And this is another one where we knew we were going to have a big fight on our hand. And we also knew pretty early that it wasn't going the way that we really wanted it to. But we also had some really strong parties, including the United States, who were looking for increased protections for lions at this COP. And so lions are obviously, not obviously maybe, but they are now being used as a replacement product for tiger bone wine. And so we're increasingly seeing trade in bones. So the US and the EU, negotiating with a bunch of parties who were against the uplisting of the species from Appendix II to Appendix I, came up with a consensus document, which is okay. It provides some additional protections. What it does is it calls for no more bone trade from wild populations, and it imposes a quota on South Africa canned lion bone hunting. And like with rhino, the canned hunting in South Africa is a major source of a lot of the wildlife that's coming into the international market from this. That sounds okay. That's a relatively good compromise, other than the fact that there's almost no bone trade coming from wild poached lions. It's almost all coming from the captive lion population in some of these countries, but particularly South Africa. And establishing a quota, depending on what the quota level is either going to be a good or a bad thing for the species. Okay, again, even more quickly, this is they revised prior resolutions related to illegally traded and confiscated wildlife. This is something IFAW has been working on for a long time. In the past, there's no regulation of what happens to those animals after they've been seized. And so there's been encouragement that they be repatriated to their countries or just killed. And so for the first time, we've actually got into place some really good welfare language, and we're moving forward with trying to get the countries to do a procedural assessment of what their systems look like for management of seized live wildlife. And so we're in progress on this one. So the fact that the CITES parties are interested in moving forward on this issue and have incorporated welfare standards is a really big move forward. It's not something that the CITES treaty itself officially regulates, but it's certainly something that's an add-on to it. And it's really great to hear that the parties continue to be supportive of maintaining these types of welfare standards while legal processes and potential rehabilitation and release efforts are underway. Internet is another issue that's internet trafficking is another issue that IFAW cares a lot about, and we have a number of reports that have come out over the years indicating that online trafficking, particularly in the developed world, is really facilitating illegal wildlife trade. And again, we were able to move forward on having this agenda item considered at CITES. It's again not something that's explicitly a part of the convention, but it's something that's regulated through the convention. We're going to be having a workshop on this with a number of the parties during this interim period between this COP and the next standing committee, which is going to be really great and hopefully get some standardization moving forward. And then finally, on live elephant trade and rhino trade, there's been a lot of, this is the trade for zoos primarily, there has been a lot of debate associated with the definition of appropriate and acceptable destinations for these wildlife. This is because of trade largely in elephants over the last couple of years, some of which has made the news, some of which was going to come to the United States and then shifted to China after there was an uproar in the United States, from Swaziland, for example. The progress here is that appropriate acceptable destinations now includes language that it must promote in situ, so on-the-ground conservation efforts. It also has language in there, although this is not final, but we do think it's going to stick during the next round of negotiations on this issue, that neither the animals traded nor their progeny may either enter commercial trade or be sport hunted, so that's a good thing. And we also have now language that recommends that all parties have in place measures to prevent illegal trafficking in their national policy documents. So that's sort of the quick summary of what happened at this COP. And I know we're at 1 o'clock, but I'm happy to stay late and ask any questions that people have.
Yeah, and we've got the room. We are able to stay in the room, so we'll just give a minute to anyone who wants to rush off to class. But those of you who want to stick around, we're happy to do a Q&A for a little bit. And thanks again, Nathan, for this.
Thank you.
Well, I guess I'll just start off and ask first. One thing I didn't mention in my introduction is that the International Fund for Animal Welfare was by far the most visible of all the non-governmental organizations at the entire CITES convention. The whole convention center was surrounded by every single light post having 2 different IFAW banners on it. And we walked into the convention hall, they were front and center of the largest booth, and were pretty much present in every one of the major conversations. And it was really good to see because they are an international group, and I think in the U.S. you're not as visible as a lot of the other animal protection groups, but like just their office, they have 14 offices all over the world, and just the office that's on the Cape, I think, has like 140 people working at it. Yeah. So they are a very large and very, very active organization. First question I have is, I remember hearing something on the elephant issue about if elephants were uplisted to Appendix I, that Namibia would do something like take a reservation and somehow be able to opt out. And it really confused me of like, what's the point of having an international agreement if any party can just opt out? And so if you could just explain that a little bit.
Yeah, so there were 2 things actually happening as it relates to elephants. There is almost always, anytime something goes wrong for a party or a position is adopted that's contrary to a party's position on these things, especially of things that are in the media a lot, they'll say that they're going to take out a reservation. You can't actually take out a reservation on a species uplisting proposal at CITES. You can. You'd be subject to sanctions under the CITES regime. It's not permissible. The second thing that was happening at this one, and it's a novel international legal issue as it relates to wildlife, is that they were claiming that for one of the elephant issues, and this is related to the annotation, is that the annotation required basically that the parties formulate what they call a decision-making mechanism, which would have allowed for future trade future regulated trade in ivory from stockpiles, legal stockpiles. And so this is mostly from elephants who died of natural causes or were culled in southern Africa. And so that annotation that came into effect as part of a negotiation between parties three COPs ago now, that allowed that one-off sale of ivory from some of those southern African countries to China and Japan, contained this language requiring the formation of a DMM that would allow for future trade, legal trade in ivory. That DMM has just been completely, the formation of that decision-making mechanism has completely stagnated. Nobody has moved it forward. Despite best efforts, they've formed working groups, but the parties are so dichotomously opposed to each other on this one that it just never went anywhere. So the language of the annotation required that the DMM come into effect before 2017, and it is not in effect. And so the countries who were arguing about the DMM during this COP were arguing, A, that they should just remove that language. So Namibia, Zimbabwe, and South Africa were arguing that they should remove the annotation language entirely, which would have allowed for regular Appendix II legal trade. Countries like the United States were arguing that there should be, that the annotation should remain in effect, and we should continue to work towards decision-making language that would facilitate legal trade. And then nobody was considering what actually happened, which is that both of those things would fail, and that in effect we still have the annotation language in effect, but no decision-making mechanism, which procedurally speaking means that nobody's allowed to continue commercial legal trade in ivory. The southern African countries who really were pushing for the deletion of the annotation, Namibia, South Africa, and Zimbabwe, all have now alleged a theory of pro non scripto, which means that they're going to try to treat the annotation language as if it had never come into effect at all, because the countries aren't acting as if they are in good faith, essentially. It comes from contracts and probate court law, and so and I'm not very familiar with it, so I'm not gonna delve into it deeply. But it's the first time that it's ever been used in this context. I don't think it's going to go anywhere. Realistically speaking, if they claimed pro non scripto and nobody wanted to fight about it, I guess theoretically they'd be able to trade amongst each other. That's not really what they're trying to do, though. They're trying to trade with largely Asia. And as long as China doesn't believe in pro non scripto, and I don't think they do, then the default will remain in effect and no legal trade will occur.
Great. Any other questions? Melissa has a question. And just to add, that very last provision that he put up about how to treat the animals after they've been confiscated is a huge one. We heard stories of how often animals would be confiscated and then they wouldn't know what to do with them, so the actual wildlife agencies would then sell the animals into trade when the whole purpose is to remove them from trade.
Oh, hi. Thank you so much for coming. Just a quick question, which is, in your experience overall, are there any countries that you found were particularly hostile to animal protection efforts under under CITES?
Yeah. It's a little bit hard to tell. The answer is yes. It's a little difficult to tell whether it's the individuals that they're sending to represent the countries, or whether it's the country perspectives in and of themselves. I think that there are, and I think it does. Getting back to my original few slides about the purpose of CITES, I don't think it's antagonistic specifically towards conservation. I think they really do truly believe that the purpose of CITES is to facilitate legal trade in wildlife, which they consider a natural resource. And so countries like Namibia, Zimbabwe, and South Africa, historically speaking, and Botswana, really all of the SADC countries, which includes Malawi and Zambia also, historically have voted almost across the board in favor of more pro-utilization. China historically, although this has now shifted in this last COP, has almost always voted for sustainable utilization of wildlife. And then there's a couple that I believe are probably more personality driven. So Antigua and Barbudo. I apologize because I actually don't remember. Antigua has almost always, the representative from that one is almost always aligning themselves with SADC. on issues that have nothing to do with them, which is really interesting. And I'm not sure what that relationship's all about. But for the most part, the Caribbean countries vote usually with either the sort of North America coalition or some of the South American coalition. But Antigua and Barbuda usually breaks in favor of sustainable use. Yeah.
How often does this group meet?
Yeah, so the Conference of the Parties is every 3 years, as Chris mentioned. There's also the Standing Committee, which is sort of the interim big conference, and that happens either once or twice before. It's twice. They have one big Standing Committee conference in between the COPs, and then they'll have one immediately preceding the COP to set the agenda and all that kind of stuff. That one's much shorter. They also have Animal Committee and Standing and Plant Committee, which meet usually annually, and they deal with some animal. Basically, what happens at the COPs is they refer out a whole bunch of continuing issues to the various committees that continue to operate between the COPs, and then they wait for decisions till the Conference of the Parties, which is every 3 years or so.
Do they have a procedure for emergency meetings? Because I'm thinking of climate change and the discovery of a certain animal or plant species that's endangered.
No, I don't think so. I could be wrong about that, though. I don't think that there's an emergency provision. I've never heard of them. It hasn't happened in my experience. I'm not aware that there's a provision that would allow it. The parties by themselves could theoretically, I suppose, just agree to have a meeting of sorts at a standing committee, for example, one of those interim meetings. But I'm not aware of any procedural rules that would allow them to do that outside of the normal setting up of animals, plants, and standing committees. I think we had a question here.
I was wondering if any of the listing proposals were for like less charismatic species and how the discussions sort of differed for those.
That's a great question. A lot of them are often, and this is true for plants too. What ends up happening with a lot of the less charismatic species is that they're a lot less controversial, and a lot of the negotiation actually happens between the parties before they get to the room. And what'll very regularly happen, and this is true for Committee 1 issues about species uplistings or downlistings, but also in Committee 2 issues around some of the legal issues, is that they just sort of bring up the issue. The process is they bring up the issue, the chair of the meeting will bring up the issue, the representative party for the proposal will read out a summary of it, and then the chair in the room will say, are there any comments? And they go to parties first, and then observers. Oftentimes there will be no comments from parties. If there's no comments from parties, almost always they'll just gavel through as a decision the proposal.
And just to add to speaking about some of the flora, one of the things we learned there was there's certain, I mean, it seemed, but there's definitely wildlife impacts. Like there's some bird, one of the birds that was endangered, and it was specifically because a certain type of tree was endangered, and that's what was harming the bird.
Yeah.
I was just wondering if you could go back to the EU-US opposition to the uplisting of elephants. I just don't understand it, because even if the population numbers have recovered, why wouldn't they take an abstention position or just not oppose it?
Yeah.
Is there a bigger picture there, or what's going on?
So in the context of the EU, there's all sorts of funky political stuff that's happening with the EU right now in the context of these international conventions. Let me see how I want to structure this answer. The original positions on these things, I think, are often coming from sort of the technocrats. And so in the United States, it's Fish and Wildlife Service that actually proposes the original positions on these things. And that goes through the normal process where the where the Fish and Wildlife Service will actually come up with the draft decisions that will likely go through an internal review process of those positions, and then they'll actually publish it in their draft positions in the Federal Register and ask for comments and all that kind of stuff. And they have a series of meetings and all that kind of fun stuff. In the EU, I think it's probably a very similar process from the early stages. The challenge the EU has is that because it's a whole bunch of countries that they need to remain, and they are trying to remain harmonized in their positions, they go through that initial process, but once they make a decision about what their positions are, they almost never change them. They'll change procedural stuff, but it becomes much, much harder to get individual countries within the EU to flip on any given issue, although it has happened in the past. But for the most part, they sort of vote as a block. There was an interesting, really, in the first day in plenary, they open up with procedural issues. And the European Union actually was trying to push through a procedural shift that would have allowed for one country in the EU to show up and vote 28 times, one for each member, which would be tremendously unfair from a resourcing perspective. But that failed during this process. But that was the first drama of this COP. That was during the first morning session of this COP. So there, if anything, I think, and this is just my perspective, is moving a little bit more towards a harmonized position in the EU, which will probably make them more unlikely to change their positions once they've come up through that technocrat-y type of bureaucratic process. The US, there's more flexibility, and so I'm not sure exactly what they were thinking from a political perspective, other than they are scientists and they believe in the biological criteria, and because elephants are split into distinct population segments, they're all for the elephants remaining on Appendix I who are currently on Appendix I, and don't believe the southern African populations, which are larger, have had substantial enough effects on them to qualify under the biological criteria of CITES.
And I think maybe karma for that, my understanding too, with the new system for a while, like the EU was being counted as one vote instead of 29, so they had to solve that, so that's what they get.
I'm wondering if there's an animal that's threatened by both trafficking and habitat destruction, if there's anything CITES can do to address the habitat destruction aspect.
That's a good question. I think the answer to that is probably yes. And so, and what they're currently doing to address sort of those issues related to non-commercial trade issues is to work with some of the other conventions. And so, for example, there's been a huge push over the last couple of years, and under John Scanlon's leadership of the Secretariat, to work more closely with the Secretariat of the Convention on Biological Diversity. That's where a lot of the livelihood issues start to come in, and through that, GEF funding. And so GEF funding is associated with the World Bank and also funds the work program of the Convention on Biological Diversity. And so there's millions and millions of dollars that flow through CBD and World Bank and GEF for a lot of these bigger conservation projects. I think the vision is for CITES to sort of maintain its scope of work on commercial trade, but to create linkages with a lot of the other international conventions that work on some of those other issues. Law of the Sea is another one.
Oh, one last question from Delcy. You get the last question. We got the janitorial staff ready to come in on us here, so you get the final word.
Thank you. I have a question, but first a comment that goes to your point. I think on the issue of the U.S. position on uplifting African elephants, I don't think we can ignore the fact that U.S. zoos are highly invested in continuing to import African elephants, and that the head of the U.S. Fish and Wildlife Service recently accepted a position as the head of the Association of Zoos and Aquariums. Yeah. So I think that's important context to have. My question is if you could talk a little bit about the fact that captive members of Appendix I species are given the lesser Appendix II protections, and that also extends to wild captured species who are being disguised as captive bred. And I think there was a proposal this year to revisit that, and I'm assuming that didn't go anywhere, but I'm wondering if that, I guess, what are, in your view, what are the implications of that, and do you think it might change at some point?
Yeah, the trade in captive bred Appendix I species, yeah. So that's
being treated as Appendix II.
Yeah. So that's basically your answer. That's how that works. So wildlife Appendix I wildlife bred in captivity under the current decisions is treated as if it was an Appendix II species. And so this is most prevalent as it relates to the Southern Africa populations of rhino and elephants. And so what that means is that for those countries, it requires just that export permit from those countries. Most of the developed world countries, including the United States, have enacted stricter domestic measures that require an import permit as well. That's true of Europe also. And so, as those are usually for those countries, the importing countries, I think for the most part that covers that specific issue. It doesn't cover it for places like China, where that law doesn't, the stricter domestic measure does not exist. And so, if that becomes more of an issue, it's certainly something that we can continue to work, and people are continuing to work on. We are continuing to work on it. It is going to standing committee for further definitions of appropriate and acceptable destinations and that stuff. And so, unfortunately, the next, I was talking to Chris about this before we started, the next standing committee isn't scheduled until November of 2017, and no work will happen between this COP and November of 2017. They're trying to move it forward. We were really hoping that they would use the standing committee that immediately follows the conclusion of plenary at the COP to set up working groups, so some of the work could continue in that year, essentially, but they didn't end up doing that. So we're on a big holding pattern with some of the stuff that's moving to standing committee, which is unfortunate for issues like that one. Yeah.
Well, thanks again, and help me in thanking Nathan Herschler for joining us today. Thanks.
Yeah, thank you guys.